Well, my respected and talented viewers, this is Advocate P. A. Demarari from Ahmedabad, Gujarat State, Bharat. Today I come with a special video on a new topic, that is electronic evidence. I'll discuss about it special provisions as to evidence relating to electronic record. Now I'll press into service the various provisions of the Indian Evidence Act. Section 64, 65B, 65E. It discusses about admissibility of the evidence. Section 65A. Special provisions as to evidence relating to electronic record. Section 65B(4) of Evidence Act is a mandatory requirement of law. Now what is that mandatory requirement? Certificate required under Section 65B(4) is a condition precedent to administrative evidence by way of electronic record. अगर कोई आदमी आके बोले कि मैंने तो फोटोग्राफ ले लिया है, that's not enough. हमने तो बात टेप रिकॉर्ड कर ली है, you just can't get any result out of it. So, I repeat, certificate under Section 65B(4) is a condition precedent for admissibility of evidence by way of electronic record. Now, this has been said by learned and Honorable Supreme Court of India in Anwar P. versus P.K. Basir, 2014, 10 SCC 473, is the law declared by the Honorable London Supreme Court, India, Section 65B of Evidence Act. Now the question arises, when the required certificate under Section 60B(4) is not necessary. It is not necessary in all the cases. Then in which case it is not necessary? I'll tell you. The required certificate under Section 65B(4) is unnecessary if the original document itself is produced. This can be done by the owner of a laptop, computer tablet, or even a mobile phone by stepping into the witness box and proving that the concerned device on which the original information is first stored is owned or operated by him. He has to come before the court, appear in witness box, give evidence of oath. Then it is not, certificate is not required. Here also there is an exception. Exception proves the rule. In cases where the computer happens to be a part of computer system or computer network and it becomes impossible to physically bring such system or network to the court, then the only means of providing information contained in such electronic record can be in accordance with Section 65B(1) together with the requisite certificate under Section 65B(4). Oral evidence in the place of such certificate cannot possibly suffice, as Section 65B(4) of Evidence Act is a mandatory requirement of the law. For this argument, I rely upon citation 2022 in bracket 2, Crimes 243, Supreme Court of India, Ravinder Singh alias Kakku versus State of Punjab. Para number 20, page number 250 to 51, para number 21, page number 251. Now, new law will come into effect from 1st July 2024. That is Bharatiya Sakshya Adhiniyam 2023. Now, Section 62, special provision as to evidence relating to electronic record. In new law, this section is there. Section 63 Admissibility of electronic record. Section 63(4). Certificate as Section 63(4)(c) to be accompanied with electronic record evidence. Under Section 63(4)(c), certificate to be filed by party and also to be filed by the expert. Now see, these are the two certificates, like this. Part 1 to be filled by the party. This certificate is to be filled by the party. This is a new law which comes into effect from 1st July. But let us update ourselves right well in advance. Then part B to be filled by expert. In existing law, only one certificate. Now in new law, there are two certificates are required, one by the party and one by the expert. This, you have to fill up this. This is format of the certificate. Original record is a must. Computer, mobile, social media platform recorded and stored contents are required. Electronic record to be proved as per BSA Section 63(4)(c). BSA means Bharatiya Saksha Adhiniyam 2023. This is over. Now, whether in existing law or in new law, you are given this, you have fulfilled the requirement. But does not mean that you will win the case. Then you have to face the defense advocate, learned defense advocate, competent defense advocate. He will cross-examine on your all evidence produced before the court. You have to face the effective cross-examination. If you can face it in a nice way, then you can win the case. Otherwise, in spite of all these things, you can lose the game. Hope you have enjoyed this video. If you like it, subscribe it, like it, and share it. See you in the next video. Thank you, thank you, thank you. Namaskar.